So far as the UK copyrights in the songs are concerned, it is intended to operate as an immediate assignment of all the future copyrights which the member may own under Section 11 of the 1988 Act. Importantly, it is intended to regulate the position and have effect from its date, with the consequence that any later assignment by a member of any future copyright must take effect subject to it. Put another way, the copyright in a song written by a member pursuant to a later commissioning agreement is a right which the member may own or may acquire or own within the meaning of Clause A. So as a result of this, it's been held that UK copyright coming into existence, upon the UK copyright coming into existence, the UK PRS was entitled under the 2004 membership agreement with the merchants, as against all other persons, including Dharma and B4U, to require that the UK copyright be vested in it. And so UK copyright does vest in the UK PRS by operation of Section 91 of the UK CDPA. So the consequence of that is, notwithstanding doing due diligence and assuring themselves that, they had obtained full title to broadcast the works, that has no bearing, and it's necessary now for broadcasters in the UK, particularly of Bollywood material, where all rights have been assigned to the producers under commission agreements, nevertheless for broadcasters to enter into licensing agreements with the UK Performing Rights Society on subsequent broadcasts of those works, even if they've already paid once over for it. So not a very happy state of affairs. Moving on to a case I spoke about last year, but I'll just touch on it briefly because it's come back to the UK High Court and the Court of Appeal, and that's the case of SAS Institute and World Programming Limited, which involves software copyright. The background to this case is that SAS produces data analysis software. WPL reproduced central aspects of the SAS program in its world programming system to execute application programs written in the SAS language. Now, WPL had no access to the source code, but it did study SAS manuals and a limited version of the SAS system, the SAS Learning Edition, to replicate the functionality of the program. SAS alleged copyright infringement, and Mr. Justice Arnold, at first instance in the High Court in London, expressed the view that functionality of a computer program and programming languages should not be protected, but he made a reference to the Court of Justice of the European Union on this issue. Now, it's important to remember that copyright protects the expression of ideas, but not the ideas themselves, and this principle is reflected in Article 1.2 of the European Software Directive. And Article 5.3 of the European Software Directive also allows for the observation, study or testing of the functioning of computer programs. Article 2 of the European Information Society Directive also states that member states shall provide for the exclusive right to authorise, prohibit, direct or indirect temporary or permanent reproduction by any means or in any form for authors of their works. Now, the Court of Justice of the European Union held that under Article 1.2 of the Software Directive, neither the functionality of a computer program nor the programming language and the format of data files used in the computer program in order to exploit its functions constitute a form of expression, and they're therefore not protected. And under Article 5.3, they also confirmed that a person who's obtained a copy of a computer program under a license is entitled to observe or study or test the functioning of that program. The Court of Justice also held that under Article 5.2 of the Information Society Directive, the reproduction in a computer program or a user manual for that program of certain elements described in the user manual for another computer program protected by copyright is capable of constituting an infringement of the copyright in the later manual if that reproduction constitutes the expression of the intellectual creation of the author of the user manual for the computer program protected by copyright. Now, the case was appealed to the UK Court of Appeal after it returned from interpretation by the Court of Justice, and the UK Court of Appeal has held that WPL's use of the SAS learning language to develop the WPL system fell within the exceptions contained in Article 5.3 of the Software Directive, and any license terms prohibiting such use, i.e. the observing, studying, testing of the functioning of another computer program, were null and void. Functionality of a computer program is not a form of expression, and is not protected by copyright. Copying the functionality can therefore not amount to copying a substantial part of the computer program. And they also held that, in the Court of Appeal, that it would be contrary to the policy of not only the Software Directive, but also the Information Society Directive, if SAS could secure copyright protection for the functionality of its program indirectly via its manual, which simply explained that functionality. So it's therefore settled law within the European Union that the functionality of computer programs can be reproduced legitimately if the source code is not copied. The last case that I'm going to discuss substantively is a case involving internet streaming, which concerns ITV Broadcasting and others and TV Catch-Up Limited. ITV, if you don't know, is the largest commercial public service broadcaster in the United Kingdom. And TV Catch-Up, in this instance, provide an internet-based live streaming service of terrestrial and satellite TV programs, including films. The programs are streamed by TV catch-ups to subscribers at substantially the same time as the original broadcast by channels like ITV. And TV catch-up services available to viewers free of charge who are required to register with the website. TV catch-up service is funded by advertising and operates through servers located and administered in the UK. The servers receive the programs from the broadcast and then extract the individual video streams identical to the original broadcast. Those streams are then encoded and then they're prepared for sending as video streams over the internet in response to a request from a user who's visiting the TV Catch-Up website. The process does not involve any storage of any part of the stream on disk or in any other permanent storage media at any point in time. Now, Article 3.1 of the Information Society Directive provides that member states should provide authors with the exclusive right to authorise or prohibit any communication to the public of their works by wire or wireless means, including the making available to the public of their works in such a way that members of the public may access them from a place and a time individually chosen by them. And at Article 3.3, it also provides that these rights shall not be exhausted by any act of communication to the public or making them available to the public. And Recital 23 of the directive also says that this should be considered in a broad terms and broad sense. So ITV and others claimed that TV Catch-Up infringed the copyright in the broadcast of their films, in particular by communicating the works to the public. A reference was sent to the Court of Justice of the European Union asking essentially, in respect of communication to the public, does this actually apply where users are already entitled to receive the original broadcasts, free to air or via satellite, without TV Catch-Up's intervention? The court also asked whether its answer would make it a difference if the live stream is delivered through a one-to-one direct connection for each subscriber, if the live stream included pre-roll advertising or in-skin advertising within the frame but outside of the viewing picture of the TV channel being broadcast over the internet, but which retained the original broadcast commercials, TV commercials, included in the broadcast. And finally, if the service provider, i.e. TV Catch-Up, was acting in competition with the original broadcaster for advertising revenues. The Court of Justice has held that Recital 23 of the Information Society Directive expressly covers any transmission or retransmission of the work to the public by wire or wireless means, including by broadcasting. Article 3.3 of the Directive, authorising the inclusion of protected works in a communication to the public, does not exhaust the copyright owner's right to authorise or prohibit other communications of those works to the public. When a given work is put to multiple use, each transmission or retransmission of that work using a specific technical means must be individually authorised by its author. And in accordance with the recital, communication to the public must be interpreted broadly. The Directive's objective is to establish a high level of protection for authors. The Court of Justice also caveated everything by saying that the mere technical means to improve reception in an area that had poor reception was not caught by the prohibition of retransmission because, but in this case, that isn't what TV Catch-Up were doing. The Court of Justice also held that the communication must be to the public, which means an indeterminate number of recipients and implies a fairly large number of people. They then looked at the TV catch-up system, and they said, well, it was targeted at everyone in the UK with an internet connection and a UK TV license, so that was an indeterminate number of people and implied a large number. And it's irrelevant whether the recipients access the work through a one-to-one communication. It makes no difference whether the retransmission is funded by advertising and is profit-making, and it's immaterial whether the original broadcaster and operator responsible for the subsequent transmissions are competitors. So, at face value, the implications of the CGA decision are good, it's sensible. It would concern the media industry if companies were allowed to intercept broadcasts and, without authority, retransmit them for commercial purposes. So it's good for the rights holders. It's established a wide principle that they need to authorise every transmission and retransmission of their works using specific technical means. Rights holders can still control how the public view their broadcasts, even after they've been communicated free-to-air over satellite to the public. It also envisages rights holders having the right to license multiple uses of their work. And it also is future-proof to the extent that it doesn't rule out development of new technology to transmit copyright works. The rights holders, even in those circumstances, will need to approve any such new use. But as far as the UK is concerned, there's a twist, because the case then came back to the High Court in London from the Court of Justice, and the court had to consider a defence put forward by TV Catch-Up, utilising Section 73 of the UK Copyright Designs and Patents Act. Now, Section 73 essentially provides that copyright in the broadcast of a qualifying service, which includes a public service broadcasting channel like ITV, is not infringed when it's received and immediately retransmitted via cable. The broadcast must, however, be retransmitted only to users situated in the region where the original broadcast was made, but in the case of ITV, it's broadcasting to the whole United Kingdom, so that's a pretty wide area. Therefore, to the extent that TV Catch-Up had streamed the channels to members of the public in the UK by cable, which the court found to include online transmission, but not transmission to wireless or mobile devices, the UK court has held that there was a defence under Section 73 of the UK Copyright Designs and Patents Act. So ITV have only been able to obtain an injunction preventing transmission to mobile and wireless devices. They have not been granted an injunction for broadband internet hardwired online access to TV catch-up service. In so holding this, however, the UK court, the High Court, has held that UK law is not compatible with European law and doesn't comply with the Information Society Directive. But nonetheless, the High Court is bound to follow UK law, and therefore that's why the injunction has been limited. Both parties have been granted permission to appeal, and as a result of this non-compliance with the European directive, questions have been raised in the UK Parliament as to whether or not the Act should be amended. Now, I'm going to rush through the remaining two cases that I was going to talk about because it would take up too much of everyone else's time, but Meltwater is a very long copyright case involving a newspaper licensing authority that licenses the reproduction of newspaper articles. Meltwater collect newspaper articles for customers of theirs and provide bespoke articles linked to those customers' specific interests. And a very interesting issue has arisen as to whether or not, when they provide access to those articles through a hypertext link on a web server by browsing, whether or not the end user, if they don't have a license from the Newspaper Licensing Authority, is infringing copyright in those works, which is quite a broad principle, because that would technically mean that anyone accessing any copyright protected material on the internet through a web browser could inadvertently be considered an infringer. Now, the UK Supreme Court, formerly the House of Lords, has made a provisional ruling that that isn't the intention of UK or EU law, and that the inadvertent making of infringers of everyone on the internet is not intended. But notwithstanding that, because it's a principle under the Information Society Directive, they've made a reference to the Court of Justice of the European Union to seek to have clarity across all 28 European Union member states. Finally, Football Data Co. Again, I won't go through all the details of this case, but it involved database rights, but it's analogous to copyright principles, and this concerned the location that infringement was occurring and the jurisdiction of courts. And in short, you have UK gamblers on the internet in the UK accessing a website based in Gibraltar, which was providing data on servers based in Austria and Germany. And the data on the servers in Austria and Germany was alleged to infringe a database right. Football Data Co. brought proceedings in the UK. It was argued that the UK wasn't the correct jurisdiction because the transmission of the allegedly infringing database was emanating from servers in Austria and Germany. It went all the way to the Court of Justice of the European Union. The Court of Justice of the European Union has held that at the very least, if the target audience are people in the UK, as in this instance, then at the very least proceedings can be brought where the target audience is. So in this case, even though the data was being transmitted from Austria and Germany through a website in Gibraltar, because it was targeting people in the UK had jurisdiction to hear the infringement case. And finally, what does 2014 bring for copyright in the EU? Well, last month, the EU Commission launched a public consultation to review EU copyright rules in all 28 member states. There is actually a closing date at the beginning of February of this consultation. The objective is to ensure that the EU copyright regulatory framework stays fit for purpose everywhere in the digital age, and support the creation and innovation to tap the full potential of the single market, and so on. One of the issues that is going to be focused on in it is the fact that copyright is seen as a barrier to the single European market, to the extent that rights holders may restrict access by country. So, for example, BBC iPlayer, which is available from the BBC in the United Kingdom and Ireland, is not accessible in France or Germany or Spain, and the same thing goes with copyright content in Spain. Sometimes you can't access it in Germany or Austria, and so on. And so the consultation intends to address this issue, as well as mooting the possibility of a single EU copyright title, which, if approved and agreed by all member states, would actually replace national copyrights in all 28 member states. So we have interesting times in the months and years ahead in EU copyright. Thank you.